Today we're going to discuss about this 150,000 green cards. We thought we got it for the employment based for the 2022, starting with October 1st. What is it a rumor, or we are going to have them, we are going to be taken back? We're going to discuss that. We're going to discuss about the EB2 movement. Should we refile using the EB2 I-140, or should we do interfiling? When you can do interfiling, when you cannot, when you can do refiling the entire 485 application. What are the advantages, what are the disadvantages? We're going to discuss about that. And of course the travel ban, we are going to update you about what's going on the travel ban. And the main, last but not the least, is that why does Congress ignore employment-based immigration? Why is that they have other priorities all the time? Why is that the press and other things don't discuss about the employment-based? We're going to discuss all these things today. Emily, we said that 150,000 green cards is already being given to the employment-based immigration in our previous mini sessions. Now, what is this rumor going on, Emily?
Yes, so we have the Department of Homeland Security funding bill that is supposed to provide funding to the department from October 1st, 2021 through September 30th, 2022. That bill did not get passed in time for October 1st. So we have a continuing resolution that continued to fund DHS through December 3rd, while both the House and the Senate work on their actual funding bills. Now, in the Senate proposed bill, which just got released on Friday, they included provisions dealing with the wasting of the green cards and all of these, the spillover that's happening. And the way that they have drafted the language basically says we're going to allow you to recapture the green cards that went wasted, but we're going to subtract all of the spillover that you've gotten for the last 2 years. So for fiscal year 2022, you end up with no extra green cards. You're basically at the 140,000. Now, this is just in a proposed bill. We have a similar provision in the House proposed bill. It does have to go through the full Senate process, so it is subject to filibuster. We need 60 votes to get it to pass, and then the House has to pass it.
Wait,
they have
Emily,
different versions.
You said it's a DHS budget bill. Why does it require to go to the filibuster?
Yes, because it's not a reconciliation bill.
Okay.
It does have to go, and that's actually what shut down the government a couple years ago, was over a DHS spending bill. They filibustered it. So it is likely to pass because we do need funding for DHS. When it will pass and what's included, we don't know. I looked back since the beginning of DHS, and for the first couple of years, they usually passed the funding bill by October 1st, but after that, it's always happened later. It's happened as late as May of the following year. So right now, our deadline is December 3rd for when they might pass this bill, and it could be amended. There's no guarantees that these provisions will be in there, but they might. So we need to be prepared.
All we need is one senator to put a stop on this one, so that it has to go through the filibuster. Most probably they're going to remove it. So we should request all the people to not cut the employment-based immigration with our senators. We will update you as the things develop more. We may give you a draft letter for you to do it, but we want you to be watchful about it. If anybody is on the sidelines of filing the 485 application, don't be. File it right now. If you have your priority date current, file it. That's what you're supposed to do right now. Don't wait that, EB2 is going to move. But one thing we can say is that if this bill, which is there in the Senate, and the version which is in the House, which has an amendment, if it goes through though, we are going to be back to square where we started in September of 2020, which used to take almost like 9 to 10 years to move 1 month of the priority date. So if these provisions will pass through, employment-based immigration is a history. I would rather advise people, have your kids early so that the kid can become 21. I mean, that's how late it's going to be by the time for any of the people to get the green card. If you recall, it took 9 years to move a date, one single day. It took 9 years. May 1st, 2010 was current in April of 2012. It took the final action date to move from that date. It took 9 years. So, and that too after the excess green cards that we got from the family immigration. But what about the people who already got the green card? Will they take it back?
Oh gosh, I hope not. No, they don't plan on doing that. What they're actually doing is subtracting that number from the fiscal year 2022 number. It actually takes the employment base below 140,000, but they've said that they won't allow that to happen. So we get at least 140,000, even though we've used more
than last year at least.
Yeah. All right, so big question with the November visa bulletin and people seeing what's happening with EB3, all the people that downgraded in October of 2020 from EB2 to EB3, now EB2 might be current. What do you do? How do you, if you want to get back into EB2, do you interfile? Do you refile? What's the difference between those? So let's start with interfiling. What exactly do you mean by interfiling? Is it as simple as submitting the medical through Interfile like we've talked about before?
It is as simple as that, Emily. However, though, the immigration does not act on it just like the way they did in the medical. We have seen so many people getting the green card when they interfiled their medicals. But when it comes to the interfiling the I-140, they need to go and change a lot of the formats because they have an I-140 of EB3, the underlying I-140. Now they have to change it. Sometimes some of the officers will get the point and change it. Sometimes the officer don't. Sometimes it may take a couple of years for them to interfere, especially when these Chinese nationals, Emily. I've noticed that when we used to do interfiling things, it used to be just like Los Angeles lanes. And by the time the officer gets to the EB2, guess what? EB3 moves forward. Then we do interfiling again. So it's a little bit caution when you're filing and interfiling, unlike the medicals where a lot of people got benefited and some people did not. Here, there may be some damage also because it takes a long time for them to move, and then later on if the EB3 moves, then you have to do interfiling again.
Okay. Can you interfile if you have already started using your GCEAD from the EB3 filing?
Absolutely, you can. If you are working with the same company, Emily, even if the people have used the GCEAD, even if they have used the advanced parole, even if the spouse have used the EAD and advanced parole, interfiling can be done absolutely no problem.
What if I've already used AC21 and left that company?
If you have used AC21, left the company, you cannot interfile using the previous company's I-140 under EB2. The reason behind that, Emily, is that I-140 does not belong to the new employer. It belongs to the old employer. Only old employer, the previous employer that filed for I-140, can authorize that I-140 to be used. So if the people have joined to the new employer, they want to use the EB2, they will have to file a labor certification I-140 again to use the interfiling, Emily.
What if my EB3 downgrade I-140 is still pending? Can I interfile and get into EB2?
You cannot get the green card, Emily. Even though you can file the interfile, you cannot get the green card. The reason is that what they look into is that when you file the 485, was it approvable at that time? Was it approvable at all periods of time afterwards though? Since you filed an adjustment of status, it was only based on the I-140 for EB3 because in October of 2020, the EB2 was not current. So we still need the EB3 approval for us to, it makes only sense after the EB3 is approved to interfile for EB2.
Is there any filing fee associated with interfiling?
No, there is no filing fees associated with the interfiling. Absolutely none.
Do I have to use my company's lawyer or can I use my own lawyer for that process?
You have to use the company lawyer. The reason is that, or company can authorize you to use your own lawyer, but you need company's authorization because the I-140 belongs to the company. It's not like medical. Medical is yours, your own personal thing. So you can use anybody, you can do by yourself. We have recommended all the people to do by yourself. We have given the link, but that's not the case when it comes to the EB2 interfiling, Emily.
do I need to wait until my final action date would be current in EB2 to interfile, or can I do it beforehand?
You could do it before the final action date of the EB2 becomes current, but I will tell people not to, because who knows, these dates can move front and back. If your final action date is not current on EB2, you do interfile, and then guess what? EB3 moves forward. Then what will happen? You actually, did damage to your 485 application. So there's no purpose of doing interfiling for EB2 if the final action date is not current.
What if my EB2 approval is actually through my spouse? So I'm the main applicant for my EB3 downgrade, and now I want to use my spouse's EB2 I-140 to interfile and have my spouse be the main applicant.
Technically, that's not allowed, Emily, as I pointed out, because in October, though, he was not current. In October of 2020, he is not current at that point of time. He could not have filed the 485 at that point of time. The dependent spouse could not have. So that should confuse the whole system. So I advise not to. If you are eligible for refiling in that case, I would strongly advise to refile. Don't interfile in that particular case. And we're going to address about refiling later on.
Yeah, so getting to refiling, what exactly do you do if you're going to refile?
You have to file the 485 application. Since your I-140 is approved, you have to file a 485J. Medicals, EAD advance parole, just like the way what people have done in October of 2020, they'll have to file the entire fresh application again, Emily.
So treat it as if you've never filed anything.
That is right. You are going to mention that you did file the 485, but all applications have to be filed again, including photographs, medicals, everything has to be done again.
What if I've used my EAD or my advanced parole and I'm no longer in my non-immigrant status?
If you're not in non-immigrant status, if you're already in adjustment of status, though, you cannot do fresh filing because you must be in a non-immigrant status to file the 485 applications. You lost the opportunity. So at that point of time, the best way is to actually interfile.
So that applies for all family members.
That is right. All family members. Even one family member has used the EAD. Practically, it gets all, practically, not legally, practically, it gets all the entire family not be able to refile the entire 485 application.
Now, I've done a number of consultations on this since the November bulletin came out, and I keep getting told that other lawyers or their employers are telling them that you cannot have two 485s pending, that you need to withdraw one first before you file the second one. Is that true?
No, it's not true. In many instances, there are two 485 applications that have been pending. We were a little bit hesitant before, Emily, in advising people to do the two filings at the same time. But after having all the experiments done in the employment based itself, using the same labor certification with two I-140s, we are fine right now. We did not have any problem. Now, previously also there are cases where family immigration and business immigration where people have filed through employment based and they backtracked and they were maintaining the non-immigrant status. We filed the entire 485 application again. We didn't have any problem at all. But with regards to the employment based, using the same employment base, we were hesitant a little bit before, but we have no problem. We have no problem in getting anything done. Now, however, though, there is a chance the USCIS may request us to withdraw one of the 485 application. That is especially when they are able to adjudicate one of the things. I'm going to give you the green card. Why don't you withdraw one of the other things?
So if I know that's going to happen, should I just go ahead and withdraw the first one when my final action date is current on the second one?
I used to advise that, especially on the family immigration to business immigration. But when it comes to the EB3 and EB2, Emily, they keep moving differently, though. So that's where I have a problem. When they're moving differently, sometimes EB3 might move forward. So I would not withdraw it at this point of time. I would keep both the things going on. Yes, if I see a lot of backlog in EB3 and nothing moves, after a couple of months, I may decide to withdraw. But at this point of time, I will not do that.
And so we need to pay the filing fees again.
Yeah, that's the thing. You have to pay the fees. You have to do the medicals, pictures. And there is another thing, Emily, is the disadvantage in refiling the entire thing, other than fees, is that if you were to want to use the EB2 and you want to move out of the company, though, The 180-day clock starts from the time you refile the entire application, where you want to move from company A to company B.
Now, will they reuse biometrics from the first filing?
There is a chance they may reuse the biometrics. There is a chance for it, but there is a chance they may request you to come to the biometrics again.
So what are the advantages of doing a second filing and keeping both pending?
One definitely is that you get the opportunity to sail in both ports. Whichever reaches the destination, you can claim that thing at that point of time and then get the green card. That is the best opportunity of the advantages. The second thing is that, Emily, whenever we file the I-140 plus 485 application together as a package, though, most of them ended up in Texas Service Center. There are some cases that ended up in Nebraska Service Center. Very less, to my recollection, very less ended up in National Benefit Center. But when you file a standalone 485 application, there is a good chance that they may end up in a National Benefit Center, which is starts with MSC. And if you look into the history of the adjudication, especially from October of 2020 to right now, most of the people's receipt notices, which starts with MSC, got their green card approved. Most, not all, but most. But the people who have SRC number, though, very less number of people got their green cards approved. So because they're filing a sole application, though, there's a chance that it may not guarantee. There's a chance it may end up with MSC, which have a better chance. And there's a chance that this may go through much faster than their existing application, which has been pending for a long time.
Another question I get, so if I am going to refile and I'm doing a standalone, so I hopefully can get to the National Benefit Center, does it make a difference if I include my EAD and AP? Should I wait and file those later after I get my receipt notice?
No, I'm going to file it along with the adjustment of status application itself to get the opportunity. By getting an EAD and advance parole, you're not getting married to any of the application. It's when you use those applications, then you will be considered to be getting married to that particular application. If you just file it, you never get to use it.
All right. Next up is the travel ban. Do we know what date the current COVID travel bans might be lifted?
It definitely seems to be November 8th, Emily. I mean, it's all indications are there. It's going to be November 8th. Based on my understanding, there's a lot of discussions going on in the airlines industry because these people need to plan. The airlines need to plan their things. So very good chance on November 8th it's going to be lifted.
And where do we stand with consulates? Are we seeing any improvement in getting interview appointments?
No, Emily, I haven't seen much improvements in the interview appointments at this point of time. They're still very slow to adjudicate and give the appointments. And it's very hard to get appointments in the US consulates in India. It's very hard to get the appointments in the in Canada is not allowing. Mexico also is canceling it. There are appointments available in October, but there are no appointments available in November, especially in the Dropbox. My fear is that when they go since you have a travel ban, they may still not issue the visa. So that's the reason I'm telling people to book appointments after November 8th in the Dropbox and other things, and those are not available right now.
Mm-hmm. And what about people who have been stuck outside the U.S., applied for the visa during the travel ban and got a 221G because of the travel ban?
I want them to reapply again for their respective visas so that they get out of this, because the only reason why they got 221G, if that's the only reason, is the travel ban, they should reapply and get the visa. So
they have to submit a new DS-160.
That's right.
Pay that fee again.
That's the best thing.
All right. And, what are your thoughts on what's going on with Congress and employment-based immigration reform? Why do they never seem to get anything done that helps employment-based?
I don't know. I'm a baby of the employment-based immigration, Emily. I've been born into it. So you have to tell me.
Well,
I just came on a H4 visa, got my green card, so I'm born into it.
I think that the Democrats particularly like to utilize the employment-based as a bargaining tool to help get some of their more comprehensive reforms across. And just some of the comments that have been made recently when we're talking about Plan A, Plan B, Plan C with the reconciliation bill, and saying, well, I want to help families. I don't want to help businesses. That was one of the congressman's comments. I can't remember if it was a congressman or senator, but this was on Twitter. you are helping families. These green cards are going to people. They don't go to companies. How do they not see that? This is not anything related to business. It's providing families through the employment-based system. So I think they just treat them completely differently, very unfairly.
Yeah, they treat the individuals as businesses, not as individuals. That's the reason in our draft letter for you to contact Congress, which has been provided below, we requested you to write about your story. Though we in general do not recommend signing petitions which are like routine. 10,000 people sign those petitions. Those don't go much anywhere according to us. But the draft letters that we have given descriptions with regards to what do you do, what is your family, where do you live at. Those are the things that the senators and the congressmen need to know. You as a family, not as part of your company's organization, but you as an individual, you as a father, you as a mother, you have you as a child. I want those things to be written, those things to be pointed out very clearly.
Ready to go for questions?
Yeah. Emily, I have some questions about it. Now, this is another question. My green card is not approved yet. I am documentarily qualified. So still when the dates go back, will I still get the green card?
No, generally no. So just because you're documentarily qualified does not mean they've actually assigned you that immigrant visa number. And that term documentarily qualified really is related to consular processing. For those that are outside the US, they use that as a method to decide when to schedule the visa interview. But it's really not, I don't think it's relevant to filing adjustment of status. And just because they've received all of your documents does not mean that they're, you've been assigned an actual visa number yet.
Emily, you have this experience, so I'm going to ask this question though. For the people who have filed the 485, now, of course, the things are getting backtracked. So these kids are becoming age out. So they have to move to the student visa, especially whose priority dates are starting from January 1st of 2014 all the way to December 31st of 2014. So did you see any problem in these people getting the F1 visa when they apply? They are in H4 and they have applied adjustment of status. Do you see any problem in getting that?
Generally, you would expect there to be a problem because the F1 visa is a non-immigrant category. There's not dual intent. You're not supposed to be an intending immigrant and receive the F1 status. But we've not seen any pushback on that when we've had to file a change of status from H4 to F1 for those that are aging out, even though they may have a pending 485 application. I think USCIS realizes that you really don't have a choice. Your only option is to change status to another visa category that you qualify for, and F1 is the category if you're in school and trying to finish your degree program. So far, I think changing status to F1, even if you've got the 485 pending for a child that's aging out, is a good idea, particularly if the age is not locked in yet because your I-140 is still pending or your final action date never became current. They're still at risk of aging out and they need to have that F1 status as a backup plan.
Pyle is asking the question, I am right now on EB3, I-140 downgrade, file a 485 application. Should I maintain the AOS EAD or remain on H1B for possibility of switching to EB2 if the dates retriggers and EB2 moves forward? If you're working with the same company, even if you are on adjustment of status EAD, for interfiling though, you do not have to be an H1B. If you want to refile your entire application though, at that point of time, you have to be an H1B. So technically, it's not mandatory for you to be on H1B if you plan to use the EB2 of your employer. Now, here is another note, Pyle though. However, if you move out of the company though, the company that has EB2 and EB3 approval, if you want to use the EB2, the new employer has to file entire Perm and I-140 again. So that is more crucial for you, Pyle, rather than actually whether to maintain EAD or H1B.
Question from YouTube, is there anything in the budget reconciliation bill that could help employment-based cases? So the difficulty with the reconciliation is we don't actually have a Senate bill. We have the DHS spending or funding bill, but that's separate from the reconciliation bill. We have the House version of the reconciliation bill, which is very favorable for employment-based, but nothing from the Senate, as they keep having to go back to this parliamentarian and get their opinion on things. And now we're on to Plan C, which seems to be some sort of temporary protected status for undocumented immigrants, nothing related to employment-based. Can they still include employment-based in the reconciliation? Yes, but we don't know if they will.
Raj has this question. My priority date is 2021. When will I get the GC? Will I get it in this lifetime? Assuming that everything remains as it is, you will not get the green card in your lifetime. We are not speaking about even if they don't take the 150,000 green cards, everything remains as it is and it goes on. Here is the reason why you will not get the green card though. Every year, there are only 140,000 green cards, but when the 140,000 gets filled out, a particular country, no country can take more than 7%. So they'll cut the country off. Assuming, I did some assumptions on you, Raj, that you must be from India. Otherwise, anyway, your priority date is current right now. You don't have to worry about it. But so since you are from India though, the priority, so we can only be allocated 7% of the 140,000, which is approximately 10,000. Now, here is the thing, when it comes to the H1B, there is 65,000 plus 20,000, so that's approximately 85,000 H1Bs. 60% are given to Indians though. And then we have people coming on EB1As that are claiming that will take approximately 2,800 off the 10,000 that are left over. So practically only 7,200 are left. So out of those 7,200, Mr. and Mrs., typically we calculate as 2.5. So 7,200, we're speaking of approximately around 3,200 to 3,500 green cards will be given every year, compared to approximately around 45 to 50,000 H1Bs. So that's a huge number. Every year there's a backlog of 10 years. And we already have a backlog from January 1st of 2015 to right now. So that's 6 years. 6 multiplied by 10 plus 2021, 70 or 80 years. I'm assuming that you will only live for 100 years. So that's the reason, no, you will not get the green card. I want you to plan on alternative things. Either Canada is maybe a better option, and I want you to be realistic, to plan your life as you go on. Now, definitely, we want you to be in the boat. We want you to keep writing letters to the congressman. We want the legislation to be changed. We want the allocated green cards to be given to the employment-based immigration. We expect that you do support our advocacy efforts, and you will take on more and do more advocacy efforts. But at the same time, I want you to be realistic and don't live in the la-la land.
Nishvik says, my company won't file for an H-1B after I receive my EAD. What are my options? How safe is it to be on the EAD, and for how long? It's not necessarily a bad thing. We've said before that to keep filing these H-1B extensions year after year, once you filed the 485, it's very expensive, and there's sometimes more risk in a potential H-1B denial compared to relying on the EAD. Situations where you would not want to rely on the EAD, number one, if your I-140 is not yet approved, we would recommend you continue on your H-1B. If there is a Child Status Protection Act issue where you have a kid at risk of aging out and they have not yet switched from H4 to F1, you need to continue your H-1B status so they can continue their H4 status to be able to make the switch to F1. And then if there's any kind of red flag in your 485 application that could cause an issue that might ultimately end up with a denial, because once you move to the EAD, if your 485 gets denied, you have no underlying status to remain in the US after that point. But for a lot of people who have the I-140 approved, there's no kids aging out, and there's no issues with the 485, it can be safe to rely on that EAD, and you can stay on it the entire time your 485 is pending.
Currently, how long the USCIS is taking to generate the 485765 and I-131 receipt notices? I would safely say that it's 3 weeks. So in fact, just before I came here, I checked my checks were been cashed, which were been received on October 1st. 3 weeks is a typical time, that is, but there are some cases where we are noticing we're getting it within 10 to 15 days also.
Yeah, I feel like the ones filed at the end of September are taking a little longer than the ones filed early September. Prashant says, if the spouse uses the GC EAD for work authorization, does our status change to EAD? Currently, I'm on H1 and my spouse is on H4. So if the dependent spouse uses the EAD, the spouse will no longer be in H4 status and will be in adjustment of status, but that does not impact the H1B holder's status. The H1B holder can continue in H1B while the H4 spouse uses the EAD and loses the H4 status. The other way around is not true. If the H1B holder uses the EAD, the H4 holder is no longer in H4 and they become just adjustment of status as well.
Praveen has this question, and this question pops up so many times that people, say that the other lawyers are telling differently than what we are telling. How long is it recommended to stay with the same company after getting the GC issued, green card issued? 1 minute. 1 minute. I repeat again, 1 minute. Do you remember? 1 minute. Okay, in plain English, 1 minute. Now, then they point out these articles that these people have written, those people have written. Praveen, the provision requires that there must be a genuine job offer and then you intend to work. But then if you break, though, there is nothing wrong with it. In fact, the USCIS, the law clearly allows to change the company even before you get the green card. That's called AC 21 law. That allows you to change before you get the green card. You forget about after getting the green card. Now, obviously, if you intend to change the employer before you get the green card, there are some conditions to be met. Those conditions must be the job must be in a similar occupation, and there are certain slight other conditions. So after you get the green card, you can flip a burger, you can be a Microsoft CEO, you can be a lawyer like me, or you can just sit down and do nothing. Then they will point out, oh, there is a possibility of problems, and lawyers have written those articles. You need to ask these lawyers, what are the probabilities? There's a difference between a probability and possibility. When you ask a possibility, it could be possible, that's a normal word. So what are the probabilities? Have we seen any of the people who got their green card, they left the companies immediately? Have we seen any of their citizenship or green card getting denied? Absolutely not. We have never seen it. You're pretty safe. Your intent was to work, but that's fine. You change your intent because after you listen to Rahul Reddy and Emily Neumann, you change your intention. That's perfectly right. You can change it. Make a note of it, make a copy of the recording, and then change it. You're good.
So Janya wants to know, when is the EAD considered to be activated? So when we submit it for an I-9 verification, when payrolls run using the EAD, there's two ways. Number one is if you join a new employer and you show that employer your EAD for proof of employment authorization rather than filing an H-1B extension. Now you start working for that new employer, you're using the EAD. But it's also in a situation where you stop working pursuant to your H-1B status. So you can just choose and decide in your mind that I'm stopping working on H-1B and from tomorrow I'm going to be on EAD. There's nothing filed with USCIS. Nobody else has to take any action. It's just in your head, today I'm now going to start using my EAD. But it automatically happens if you stop working pursuant to the terms and conditions of your H-1B. Maybe you go to work in a different location than what your H-1B was sponsored for. You're no longer an H-1B. From that day forward, you're using your EAD.
Lakshman Lucky, is there a chance EB3 can move forward? At this point of time, because they wasted 80,000 green cards though, and they're planning to waste some extra green cards this year also. there are very less chances for the EB2, at least in the next 1 month. That means in the December. Emily, I have some questions for you. The questions are coming on. What about the reconciliation bill? Where is it? What are the hopes of it? This is from Praful Vyas from YouTube.
Yeah, so everything is with the Senate right now, and with the reconciliation bill, we still don't have an actual bill. So all of the different committees are supposed to provide their suggested language to include in one big bill for the Senate to ultimately vote on. We don't have any of that from the Senate Judiciary Committee because it's being held up by this parliamentarian. Because they keep asking permission to include these immigration provisions in the reconciliation bill. It sounds like the Plan C version of immigration through reconciliation is going to be submitted to the parliamentarian very quickly, maybe even tomorrow. We'll probably get a pretty fast response on that. But again, all of these proposals that are going to the parliamentarian really have not mentioned anything to do with employment-based. So it's very possible that we may still see in the final Senate version of the bill that they include employment-based reforms similar to what's in the House bill. And a lot of those, like the recapture provisions, have previously been included in Senate reconciliation bills without going through the parliamentarian previously. So there's some, prior history of that happening. It could happen again. We should ultimately get a reconciliation bill from both the House and the Senate. They may be different. Then they have to conference together to come up with a final bill that finally makes it to the desk of the president. So we still have a long way to go.
Deepak Bhatia has this question. My prior date is April 2012 in EB2 with your previous employer. My new employer filed Perm today in EB3. Do you recommend to switch to employers EB3 retrogressing? One thing, Deepak, is that we always recommended people, if they are eligible for it, should file under EB2 though. Even though when the EB3 was advancing, Perm should always be filed under EB2. If you have the Perm filed under EB2, you can use the same Perm for I-140 for EB3 or EB2. But if you file the Perm for EB3, we cannot use it for EB2. In your case, though, I don't know why you have been waiting for all along. Now, since it's been filed under EB3, Deepak, I would jump the ship and go to the old company. If the doors of that company are open some way or another, I will crawl there and go and somehow get into that boat as soon as possible. Do it as soon as possible. That's what I would do, because getting in the boat is absolutely important, guys. And we're going to discuss about what's going to happen if the priority date moves back. Emily, what's going to happen with this application? Will they not get an EAD, or they get an advance parole?
Yeah, you do still get the EAD and advance parole. Everything gets processed until the point where they would normally approve it. Yeah. They can't approve it, but everything else processes.
And Deepak, believe me that having a EAD on 485 application, maintaining that EAD is 10 times more easier than that of maintaining the H1B and H4. The filing fees is $0. Even if the documentation is so less. We charge some money, but because it's an administrative cost we charge. What is there to look into? A EAD and advance parole extension, if all the boxes are ticked and all the things are all right. My legal assistant is a very, very efficient legal assistant. She manages, practically goes through more smoothly. When it comes to the H1B letter, H1B, we need to have the end client letter, vendor letter. We need to have the documentation properly. We need to have the position must require a specific degree as a minimum requirement, your degree requirements, your education evaluation is properly done or not. All those things need to be looked into. Oh, I forgot one thing. The main thing, filing fees, the humongous amount of filing fees, plus the premium processing filing fees, and the same thing with regards to the H4, maybe not big filing fees, and there's no premium processing for H4 plus EAD. So obviously getting into the boat, if anybody who has not filed the 485, you have an opportunity to file it right now. You file it right now. You file it. You absolutely need to file it because it's good for you to get in the boat.
Rod's from Facebook already applied for the 485 in EB3, and now that date is going to be retrogressing in November. Also eligible for EB2, but the attorney is saying that it's not recommended by USCIS to file an EB2 when you have an EB3 pending. Is it true? There's zero truth to that. There's no guidance from USCIS that says don't file a second 485. There's nothing prohibiting that. And a lot of people ask me, well, how can I convince my lawyer that this is allowed? It's a little bit difficult because you can never prove a negative. How do you prove that there's not a law that exists that says you can't do this? There is no law that exists, but it requires you to look at every single law that does exist to prove that it doesn't exist. But there is no restriction on that. I don't know why that is being said. I'm hearing it a lot right now. Never had a problem with filing 2 485s for the same person.
For the visa regression, can we do a writ of mandamus? Unfortunately, no. Even for the 485 delays, we tried many lawsuits. We are not successful in it. One guy is suggesting it's going to take 495 years, hopefully, so that will take that long. Could be. I mean, that could be possible. If you guys are alive, yes. So that's the reason why we need to work with the Congress, guys. We need to work with the Congress.
Krishna, any updates on H4 and H4 EAD premium processing or the lawsuit or where all of that stands? No news on premium processing. I think the kind of general, I guess, rumor right now is USCIS is trying to get normal processing times down to 6 months, and maybe then they will implement the premium processing. I will say I feel like they are making progress on that. I have seen a number of H4 extensions and L2 extensions get approved within 6 months. Just within the last 2 weeks, approval notices that have been coming in for cases that we filed back in April and May, we are seeing those approvals, even from the California Service Center, where their processing time I think is still listed as like 18 months as of today, but we have started seeing them closer to the 6 month range. I can't say that 100% across the board, but we're seeing progress, and hopefully that will mean that we'll see the premium processing become available.
Question of the day, I would call it Yaborem from YouTube. AC21 6 months rule, does it reset itself when you get the green card? No, it does not reset. The 6 months rule is not applicable. You got the green card, you are out. Good. Another question that is coming up for the age out kids, especially if your priority dates are from January 2014 to January 14, 2014 to December 31st of 2014. If your kid is aging out, since your final action date was never current, you better file the change of status to H4 to F1. As Emily has pointed out before, we have not seen any problems in people who are filing 485, change of status from H4 to F1. And previously, if they were aging out, we used to have something called a bridge B2 application. That has been taken off right now, so which is a good news for you. So even if the kid ages out while the F1 is pending, they don't need to file a B2 bridge application, which is a good news. So I would prefer, Manish, that you file the change of status for your child here in United States instead of going to the consulate. We don't see any reason for your child to go to consulate.
Venkat says, I'm on GCEAD 485 still pending, I-131 not approved for the dependents. Can they travel and get the visa stamp with an L2 petition? Well, if you are still maintaining L1 status and they are maintaining L2 status, they can travel and get the L2 stamp and come back into the US without abandoning their pending 485. But if you've no longer kept your L1 status and are using the green card EAD, they're not eligible for L2. The only way they can travel is with the advanced parole.
Akash has this question. EB3 priority date is February 2013. Should I downgrade right now this month or wait for the next visa bulletin to be? No, downgrade. File it right now for 485 application this month. Because if you want to, you can still file one more 485 later on, because you don't know whether what will be there in the December. Sometimes it takes 9-10 years for the priority dates to move. Right now, you're current under EB3 this month, not next month. So definitely, I would strongly recommend to file. You may be risking a little bit money, but you don't want to be on the sidelines for a decade and maintaining the H1B. I would file a 485 immediately.
Another common question I've been getting with this retrogression, this is from Atul. I received my EB3 green card EAD and now my priority date is backdated, it's retrogressed. Will I be able to renew my EAD even though my date has retrogressed? Yes, every time you can continue to renew your EAD regardless of whether your date is current or not. What makes you eligible for the EAD is simply, and the AP, is simply having a pending 485. Your 485 continues to be pending even if the date is no longer current, so you can keep renewing that until you get the green card.
Our predictions did not work out good, guys, with regards to the priority date. There's no doubt about it. We get a lot of criticism. I take it positively. I mean, we have done a lot of efforts to utilize the employment-based immigration last time. Out of the 120,000, we got wasted about 80,000, at least 40,000 came. I'm proud of it. We wrote letters to it, and of course the State Department put a note just so that our audiences don't write any more letters to them. We got the USCIS respond. They definitely did adjudicated a lot more applications the last 3 months. In fact, I would say that in the last 3 months, they adjudicated more applications than what they did in the first 9 months. I take the blame for having those many green cards getting approved. Thank you for it. But I take the blame of, we also take the blame that our predictions with regards to the priority date did not went correct. We take the blame for that too. We have to keep doing our efforts, guys, and I always want to be at a positive outlook and still keep the ground reality of what's going on. If we would have had the 80,000 green cards given to us, though, the priority dates would have been quite different than what they are right now. And if they are planning to use the 150,000 green cards that we got this time, the things would have been quite different, though. If the State Department would plan it properly, because that it will take, they are taking 2 years to get the green card, though. Why are they not having 2 years of amount of green card applications there? So these things still need to be addressed. So hopefully, so next year they'll address it.
Sunil has 2 I-140s, one in EB2 and one in EB3. Both of them are approved, both with the same employer. And he wants to know, does USCIS automatically approve the 485 based on whichever I-140 happens to be current first, if they're filed by the same employer? Well, it all depends on which I-140 you use to support your 485 filing. And then if you later interfile, then you would move into the other category. But do they automatically know that you have to and approve you in whichever category is faster? No, I don't think so.
For applying the green card for the nurses, though, visa screening is absolutely required. Even though you are on the TPS and now you're trying to move to the 485, visa screening is still required, because if your profession is nurse profession based on the EB3, you require the visa screening.
Nikki wants to know, can the aging out kid file the change of status to F1 after using the EAD AP to travel back to the USA? It depends. Assuming that the child was in H4, if the main applicant is continuing in H1B, the child was in H4 when they left, returned using the advanced parole, but the main applicant continues H1B and the child then continues H4 and doesn't violate that status, doesn't use the EAD, it should be possible to file a change of status to F1.
I have a hacking trick for that, Emily. Why not the kid travel to Mexico and come back on H4 on the I-94?
Yeah.
That's a good trick that one of the audience is an engineer in my Sunday show said, "Hey, can I not come back in advance parole and then go to Mexico and use the H4 or H1 to come back into the United States because they have the valid I-94?" I said, yeah. I mean, what the worst that could happen to these people if they travel to Mexico when they come back on H1B and H4? What's the worst that could happen? They should still be allowed to come on advance parole if they're not allowed to come back on H1B.
Yeah.
This came from people like you guys. I mean, that's a good part. When we do these things, we do get educated by you guys much more. That's a good part about it. Will NIE letter is required if we are filing the visa applications after November 8, 2021? I don't think so. The travel ban is not officially lifted, but it's almost there. So unless they go back on it, you would not require any NIE letter if you are going for stamping on or after November 8th. I don't know whether they're going to lift after November 8th or on November 8th. I would strongly recommend if you're making an appointment, make an appointment on November 9th instead of November 8th.
Vijaya asks, can H4 kids apply for the H4 EAD? Unfortunately, no, that's only for spouses. The kids are not allowed to apply for the EAD. So that's another reason why changing status to F1 may be necessary, because your child will not be able to do any kind of internship or summer job if they are in H4 status, whereas if they're in F1, they can possibly get CPT or pre-completion OPT to do those summer jobs and internships while they're studying.
Lavanya has filed an adjustment of status in EB3. Can I apply for AOS using my own priority date in EB2? Yes, you can, as long as you have been maintaining the H1B status. Tejo Ramachalla, my EAD got approved in EB3. I changed my job. My green card is still pending. Am I required to file a 485J amendment? We strongly suggest that you do. It's not an absolute thing that if you don't do it, your green card will be automatically cancelled. But it's always better to file a 485J supplement, at least when you change to the second company though. Now, it may not be strongly recommended when you change from second company to third company, but from company A to company B, the main company that filed, because what happens, Tejo, is that when the company A withdraws the I-140 now, it should not have any effect on your 485, but the officer will get confused. Hey, this guy is not working with this company. That will create a problem for your application. But if there is a 485J supplement that has been filed by a company B though, then you are in a safer position. That's our strong recommendation though.
Karthik from YouTube asks, can a U.S. citizen child sponsor the green card to their parents once they turn 21? If yes, that is our plan D. And yes, that is exactly right. If your child was born here and is a U.S. citizen, once they turn 21, they can sponsor their parents for the green card. It falls into the immediate relative category, which means there is no quota, there's no cap, there's no limit on how many green cards are available in that category in any given year. And they give out, what, 1 million?
Million of those green cards.
Yep.
And do they need to be in legal state assembly to get the green card?
No, as long as they entered legally.
Really? So if I come here on H1, I violated the entire status, my child is a US citizen, I can still get the green card?
Yeah, I'm not recommending you violate your status, but yes, technically there is.
Yeah, that's called for immediate relatives. The only entry has to be legal. After that, even if they don't maintain the status, they will get the green card. Shankar has a good question. Don't we still have the 150,000 green cards? Yes, we do. As of today, on October 19th, we do. But there is a proposal in the Congress that may take it off, may take it off. So as of now, today we do. My passport is expiring while my 485 is pending. Do I need to do interfiling? No, don't bother about it. You're good. You don't have to worry about it.
Ram Gopal wants to know, can my wife and daughter who's under 21 use the EAD? We filed the 485 in October with an EB3 downgrade. That I-140 is approved. Priority date is October 2013. Generally, once the I-140 is approved, if you don't have plans to go back to EB2 by refiling, and there's no red flags in your 485 application, it is safe to use the EAD and rely on that going forward rather than continuing to maintain your H1 and H4 status.
My child is an EAD. Will they consider this type of application for college admission? Yes. It's called as pending adjustment of status or pending green card application. That's the word that I have seen in the college application process though. So if your kid is, having an EAD, you can use that to go for college admission.
Trushit asks, any hope that the Perm processing time will go down? They continue to get worse, and I don't see them going down in the near future. Remember, the Perm, there is no filing fee for it, so it's not a fee-funded process, and they are limited with the resources that they have available. I think with all of the different Trump things where they changed the form for the prevailing wage, they changed the wage levels, it caused a lot of increased filings. With the priority date movement, it caused a lot of additional filings, so they're just dealing with that backlog, and I don't see it getting better in the near future.
Praveen has this question, and I want your discussion on this, Emily. We know that the Congress doesn't do much activity in the United States. The Parliament, we call, and you guys call it as Congress. So Praveen has this question: can the president sign an order to count the green cards only for the primary applicants and reuse the green cards, 250,000 plus green cards? Oh, it's not 250 anymore under the current law. It's 330,000 green cards that were not wasted out for the employment-based immigration.
Well, I think that there is a potential that the president could sign an order that doesn't count the dependents towards the cap, because the way that the statute is written, it sounds like that's how it's supposed to be, that they're not counted. They've historically always been counted, but that interpretation could be changed. It's not inconsistent with how the statute is written. As far as recapturing, I think that's also a possibility. I think where maybe an order would be difficult is dealing with the spillover, because that is already something set by Congress, so only Congress can change how that spillover happens, which is something that they might be doing in this DHS funding bill in a negative way.
There's also, Emily, the president can authorize people to file the 485 application when the I-140 is approved. What prevents him to allow the
statute? It says a visa has to be immediately available.
Yes, but they can parole all these people into it. He has an authority to unilaterally parole all these people and give them the employment authorization. So that is possible too. There are a lot of things. All these things we are expecting probably somewhere in February of 2022. That's when, Praveen, we're expecting president to act. He's giving time for the Congress to act. If they don't act, then he may be doing it. I don't know whether it's going to come this time or it's going to come next time. I don't know. Because he may wait until 2022 is complete, and then after the November he can do it. That's my expectation though. But we'll have to see how, because if the Congress doesn't act by January or February of 2022, they most probably are not going to act anything on the immigration at all, because 2022 is the election year. They don't want to do anything in the election year.
JKS says, does the prevailing wage determination for Perm have an expiration date where you have to file the Perm before that date after the recruitment is completed? Yes, every prevailing wage determination comes with an expiration date. The majority of them, it is June 30th of the following year. So any prevailing wages that are coming out now expire June 30th. Whether you can file after that expiration date, there are certain ways that can be done. It depends on when the recruitment was started. A lot of moving parts with that, but so yes, the expiration date may impact when you can file the Perm or not.
Anything else, Emily?
I think we're out of time for today. Thanks for joining us. And we are now on Instagram. So if you're on Instagram, check us out. Give us a like over there and see what we've got going on.
Thank you very much for tuning in.